Hey there, my name is Veronica Assis, Client Relations Liaison at Blackstone Internacional, an international advisory focused on diplomatic frameworks, global protocol systems, and cross-border institutional structures. The following analysis is academic in nature, intended for informational purposes only, and should not be construed as legal advice. Today's topic is persona non grata, how countries expel diplomats. What does persona non grata mean? Persona non grata literally means unwelcome person. In diplomatic practice, it is a legal label applied by a receiving state to prohibit a diplomat from entering in a diplomatic capacity, or to require an already resident diplomat to leave because the host no longer accepts them as a representative. 2 points are often missed. First, the concept is about consent, not proof. A host state can withdraw acceptance even when it does not publicly allege a specific offense. Second, the mechanism can be used before arrival. Article 9 allows a person to be declared non grata before entering the receiving state, and the consular treaty contains an equivalent pre-arrival option. Legal basis and treaty context under the Vienna Conventions. Article 9 of the Vienna Convention on Diplomatic Relations is the core legal authority. It allows the receiving state at any time and without giving reasons to notify the sending state that the head of mission or any member of the diplomatic staff is persona non grata, or that any other mission staff member is not acceptable. The sending state must recall the person or terminate their functions. If it fails to do so within a reasonable period, the receiving state may refuse to recognize that person as a member of the mission. Consular personnel are covered by the Vienna Convention on Consular Relations. Article 23 allows the receiving state to declare a consular officer persona non grata or any other consular staff member not acceptable. If the sending state does not act within a reasonable time, the receiving state may withdraw the exequatur or stop treating the person as consular staff. Like the diplomatic rule, the consular rule also states the receiving state is not obliged to give reasons. Typical grounds and diplomatic versus consular distinctions. Because reasons are not required, official statements vary. Where explanations are offered, common themes include alleged intelligence activity, interference in domestic affairs, repeated protocol violations, or conduct described as incompatible with diplomatic status. These themes align with Article 41, which places an affirmative duty on those enjoying privileges and immunities to respect local law and not interfere in internal affairs. Diplomatic personnel and consular personnel also sit under different legal architectures. Diplomatic agents are inviolable and generally immune from the receiving state's criminal jurisdiction. That makes persona non grata a primary enforcement tool when a host believes a serious breach has occurred, but cannot or chooses not to proceed through courts. Consular immunity is more functional. The consular treaty links immunity primarily to acts performed in the exercise of consular functions, and the consular system relies on host authorization, the exequatur, for certain consular roles, so withdrawal of the exequatur becomes a legally explicit lever. Procedural steps host states follow. The Vienna Conventions define what states may do. Protocol practice determines how they do it. Procedures differ by country, but a common sequence includes internal coordination, formal notification, a short departure expectation, recall or termination of functions, and departure with status wind-down. First, the host state consolidates the basis for action internally, often through coordination between the foreign ministry, protocol officials, security services, and, when relevant, prosecutors. In some systems, withdrawal, or PNG, is explicitly treated as an escalation option when immunity prevents prosecution or coercive investigative steps. Second, the foreign ministry notifies the sending state. Article 9 requires notification. In practice, this is usually delivered via a diplomatic note and often reinforced by calling in the mission for a demarche. Third, a departure expectation is set. The convention uses reasonable period, but states frequently specify a short deadline, 24 hours, 72 hours, or a few days to operationalize the decision. Those numeric deadlines are features of practice rather than fixed treaty numbers. Fourth, departure and status wind-down follow. Privileges and immunities normally cease when the person leaves or after a reasonable period to do so, while immunity for official acts continues even after functions end. The receiving state must also grant facilities for departure. Practical consequences. For the diplomat, persona non grata typically ends the posting immediately and can reaffirm that the host will not accept the individual as a representative in the future, including before arrival. Removal occurs through termination of functions and departure because while privileges apply, arrest and prosecution are heavily restricted. For the mission and the bilateral relationship, consequences range from manageable staffing adjustments to major diplomatic escalation. P&G declarations are frequently followed by reciprocal measures. In more severe disputes, states may recall missions or break relations. Even then, the receiving state must respect and protect mission premises, property, and archives, and facilitate departures. Importantly, the legal regime does not disappear just because relations are tense. While privileges apply, diplomatic premises remain inviolable and diplomats remain protected from arrest and detention, so removal is achieved by ending acceptance and allowing departure, not by force. Notable case studies: South Africa and Israel, January 30th, 2026. South Africa's Department of International Relations and Cooperation declared the Israeli embassy's chargé d'affaires, Mr. Ariel Seidman, persona non grata, citing violations of diplomatic norms and practice and describing the conduct as a breach of the Vienna Convention. The statement required departure within 72 hours. Outcome: a formal P&G declaration with a defined deadline, framed as a sovereignty and protocol response rather than a court process. Pakistan and India, May 13, 2025. Pakistan's Ministry of Foreign Affairs declared a staff member of the Indian High Commission in Islamabad persona non grata for activities incompatible with his privileged status, directing the official to leave within 24 hours. Pakistan also stated it summoned the Indian chargé d'affaires for a démarche to convey the decision. Outcome: immediate notification plus an accelerated 24-hour departure window. United States and South Africa, March 17, 2025. In a State Department press briefing, the spokesperson described that U.S. officials delivered official notification of Ambassador Rasul's persona non grata status. The briefing indicated privileges and immunities were expected to expire that day and that departure was required by that Friday. Outcome: a publicly acknowledged P&G action communicated through host foreign ministry channels tied to a short departure timeline. Recommended verification and response steps for missions and hosts. For host states, accuracy begins with status verification. Diplomatic and consular protections depend on category, accreditation, and host acceptance, not on titles claimed in public. UK prosecution guidance emphasizes that immunity depends on rank and that staff must be accepted and notified to the foreign ministry. It also notes that authorities must resolve immunity questions before taking further action. For host foreign ministries, a treaty-consistent approach means notify through proper channels, coordinate with protocols, security and immigration systems, and avoid actions that violate inviolability of mission premises or the person of a diplomatic agent while privileges apply. For missions, the best response is prompt compliance and controlled messaging. Coordinate recall or termination of functions, notify the host ministry of departure and staffing changes, and ensure conduct remains consistent with the Article 41 duty to respect local law and not interfere in internal affairs. If the incident involves alleged criminal conduct, missions should understand that the host state may seek a waiver of immunity from the sending state. If waiver is refused, one recognized outcome in state practice is a request for withdrawal or the use of persona non grata as the removal mechanism. Short conclusion: persona non grata is a formal, treaty-based instrument of diplomatic control. It gives the receiving state a lawful way to remove a diplomat or consular officer by withdrawing acceptance, requiring recall, and setting a departure window without needing to publicly justify the decision. Understanding the mechanism matters because it explains how states manage high-risk diplomatic conflict within the boundaries of international law. If you would like to explore diplomacy further and take a first step into understanding how international diplomatic systems function in practice, initiate a private advisor inquiry at wblackstone.com.